Hello, everyone. There are not too many of you. Please write in the chat box if you can hear me well while we are waiting for maybe some more people. Just please press plus or just tell me that you can hear me okay. You can hear me well. All right, me if you can't hear me at all, or maybe it's okay. All is okay. Thank you. So thank you for sharing your time with us. My name is Olga Rudnitskaya, and I'm legal advisor in Eltoma Corporate Services. Today, we will discuss with you the topic regarding companies in Hong Kong, its incorporation, maintenance, and liquidation. Please use our chat box to ask the questions you are interested in. I will send you all the answers after the webinar, or maybe during the webinar, I will answer you some questions. Otherwise, I will send all the answers during the day to your emails. So, hope our webinar will be quite useful for you. So, first of all, we will make a short overview regarding the Hong Kong and its economy. Then we will turn to the company registration and types of companies. We will discuss with you which company corporate documents are needed, how the nominee service is used, which compliance regulations are relevant in this jurisdiction, and which options you can choose to liquidate a company, and which one to choose depending on your needs. So starting with a short overview of the Hong Kong jurisdiction, we can say that Hong Kong is the third largest world financial center after New York and London. And as well, Hong Kong is the largest financial center in Asia and a major trade and transportation hub of southern China. So the Hong Kong economy has a high level of investment protection and quite minimal restrictions on the trade and capital movements. So according to Bloomberg, in 2016, Hong Kong continues to keep its position as the best country to do business worldwide, and it is still ranked first in economic freedom, calculated by the Heritage Foundation and the Wall Street Journal experts. So, in the first half of 2017, Hong Kong's economic growth accelerated to 4% year-on-year in real terms, so for 2% from 2016. The growth of private consumption expenditure quickened to 4.6% year-on-year for the first half of 2017 and from 1.8% for 2016. So the investment expenditure increased by 8% year-on-year for the second quarter of 2017. So you may see that it's quite a huge acceleration for Hong Kong, for a country. So for the rest of 2017, the external environment is expected to improve further, whereas domestic demand should continue to be supported by favorable employment and income conditions. So in the latest round of review, In 2017, the government maintained the forecast for Hong Kong economic growth for 2017 at 4%. So Hong Kong is, along with Singapore, the most liberal economy in the world. So opening a limited company is quite simple, fast, and quite cheap, as the government requires a fee of only 1,730 Hong Kong dollars for the company registration and a fee of 2,250 Hong Kong dollars for the business registration certificate. So actually, you don't even need to live in Hong Kong, as you can hire a secretary and get a registered office there, get a registered office address there for a quite small annual fee. So Hong Kong is a major banking center, and if you incorporate your company there, you will be entitled to open a multi-currency business bank account. For example, at such banks as HSBC or Hang Seng Bank, these banks are widely known worldwide and quite recognized worldwide. So Hong Kong has a very simple taxation system. So your company will have to pay only 16.5% tax on all profit, and in addition, you may reduce your tax to even 0%, because you may choose. There is a territorial, there is a territorial principle there, so you may reduce your tax if you will. For example, if you will run your business outside Hong Kong, but the company will be incorporated in Hong Kong, so you can reduce it to the 0%. So public bodies, which is responsible for a company registration in Hong Kong, is a company's registry. So you may see on your screens the link to the website of this registry. So the company's registry supervises the registration process of all Hong Kong companies. This body records and updates any changes to corporate structure, holds registers and annual returns. So when we turn to the law which governs companies in Hong Kong, so we can refer to the Companies Ordinance. I'm sorry, but going back to the registry, we can say that all the information which is kept by the registry is available to the public access. So documents such as general company information may be obtained by any person in Hong Kong, including foreigners, and documents are available in Chinese or English, depending on the language they have been submitted for registration. So there are two options of submission, both in Chinese and English languages. In January 2016, in January 2017, Hong Kong government decided to submit for public discussion a proposal to amend the company ordinance. So these changes concern the maintenance of registers of beneficial owners of the company. So the exceptions will be made only for public companies whose shares are quoted on exchanges, and all beneficiaries controlling more than 25% will be included in the register. So Hong Kong's Financial Services and Treasury Bureau issued a consultative document on amending the Companies Act. So if the proposed amendment is approved, companies registered in Hong Kong will be required to disclose beneficial owners and register such information with Hong Kong Companies Registrar. So each applicable company will be required to keep and maintain the register of the significant controllers. So actually, who are the significant controllers? Um, so this means either a natural person or a specified entity that has significant control over the company. So it must have more than 25% of control in the company, more than 25% of interest in the company. Or it may be otherwise a legal entity that is a member of a company and has significant control over the company. So the secretary will have to keep a significant controllers register whether or not the company in fact has any significant controllers. So it may carry out investigations. The registrar may carry out investigations and obtain information about its significant controllers. The secretary must keep information on significant controllers register up to date, including including recording any registrable change arising from any person ceasing to be a significant controller or any other change which results in any particulars for any person which is entered in the significant controllers register being incorrect or incomplete, or maybe any required updates on the prescribed additional matters noted in the register. So going to the types of the companies, there are different types of them, but the main ones are the public limited liability company and the private limited liability company. So the main difference between these companies is that the public limited liability company can offer its shares to public and easily transfer shares as it is not limited to shareholders solely. And the transfer of shares in a private limited liability company is possible only with the consent of shareholders. So the so-called preemption rights. So firstly, the existing shareholders have the right to acquire shares, and the percentage of shares belonged to existing shareholders cannot be changed without prior consent. And of course, the Articles of Association is created upon these differences. So nowadays, unless you're planning to stay in Hong Kong, you can only open a limited company. That's why we're talking about these very types. So as I have already said, you can go to Hong Kong and open the company by yourself. However, the government requires your company to have an office and a secretary in Hong Kong. So first, you don't need to rent an office and hire a secretary. They can afford to keep the costs low because the same person can act as a secretary for a lot of companies. This is the same for the office. The office of a given agency may be the registered office address of many different companies. So in addition, you can open your company without even traveling to Hong Kong. So you can e-register your company and for example, so both options are allowed, and e-registration and paper registration. So we can discuss the details by mail or by mail with you with some registered agency. Send all the necessary documents to them, pay all necessary fees, and just receive the final documents just at the country of your residence, the country you live in. So, first of all, speaking about the process of company registration, you'll need to pay the agency's fee if you will use the service of the registered agency. Then choose a name of your new company. So your agent will check whether the name is available in Hong Kong or maybe it has been already taken. Then you will receive the company name approval. Then you will have to send a copy of your passport, copy of an official document which can prove your address, prove your residence, and a questionnaire filled up questionnaire with standard questions such as your address, your passport number, the name of the director and shareholders. So all the the questionnaire which can reveal the structure of the company. And for a simple company structure, you have, unless you have some special requirements, your agency will set up your company just using e-registration, which takes less than 2 hours. You will get your company's certificate of incorporation and business registration certificate. And first you will receive these, documents via email, and the originals may follow. So prior to the completion of the registration process, the founding shareholders should sign the Articles of Association. Then all the completed application form, including the Articles of Association, should be submitted to the company's registry. For these, both options can be used either via a hard copy or a soft copy. And finally, you will receive notification confirming the approval of the company corporation. So going to the choice and approval of a name. So this is a separate procedure. And as I have already said, it can be completed both online and on the application. So the selected name should be accompanied by the company's activities and an explanation of the name if it seems ambiguous and if it seems ambiguous to the registry. For example, if you use the abbreviations or some foreign words or maybe names or other well-known geographical names and brands cannot be used. Also, we cannot use such words as royal, state, or words associated with certain licensed activities, such as school, college, church, travel agency, etc. So license must be obtained to use these words, then the name can be registered. For private companies limited by shares, it is obligatory to use the word limited at the end of the name, so the acronym LTD cannot be used. So you may see this link on your screen. So you can check the desired name prior the registration using this link. So talking about the registered address, the official address of the company must be registered in Hong Kong. Using a residential property for business purposes is not allowed, and the company secretary and registers of the company should be located at the registered address. So going to the authorized capital, first of all, the minimum authorized capital can be as low as $1 Hong Kong. So, but usually it's not less than like 100 Hong Kong dollars. However, we will suggest you to have at least 1,000 Hong Kong dollars, since the company with a small capital doesn't, small capital doesn't give a reliable impression. So once you take into consideration that the increase in authorized capital is a more complicated and continuous procedure in future than the issuance of supplement shares, so we will recommend you to um, use the authorized capital to be to be the maximum amount in any case, so that paid up capital to be how much the client wishes to pay at the time of registration. Furthermore, it should be noted that the amount of issued capital must be paid by the shareholders during the first financial year of the company and confirmed by the relevant documentation. So the amount of the authorized capital can be reflected in the company's articles of association. So the following classes of shares you may see on your screen are allowed. So first, it's ordinary shares, preference shares, shares with voting or maybe no voting rights, and redeemable shares. So discussing the corporate documents of a company. So first, it's certificate of incorporation, articles of association, resolution of directors' appointment, minutes of first meeting, register of directors, register of shareholders, and the last you may see on your screen, share certificate, is not used. There is no share certificate in the Hong Kong. There are only registers which are submitted to the registry, or some forms which can confirm the amount of shares which shareholders have, but no share certificate is used. So you may you may have heard such such documents as memorandum and articles of association. So in Hong Kong in 2014, the memorandum was abolished. So the information was which was previously in the memorandum, it was transferred to the articles of association, and no points of the memorandum, but no, not all points which have been in memorandum previously are specified in the articles of association now. So previously there was minimum information about the company required by law, which had to be specified in the memorandum, such as a company of registration, description of the present possible company's future corporate operations, responsibilities of shareholders, whether they are limited or not, authorized and paid up capital at the time of registration. And the memorandum of association is abolished completely under the new company's ordinance. So if the company is formed and registered under a former company's ordinance, a condition that was in Memorandum of Association immediately before the commencement of the new company's ordinance is deemed to be regarded as a provision of the Articles of Association of the company. So the Articles of Association now define the rules, procedures, and protocols of the internal operations of the company, which include rules for the conducting of shareholder meetings, classes of shares, rules of the share or rules of for share transfer, protocols to increase or reduce authorized capital, preemption rights, and its execution, appointment, resignation, dismissal, and power of directors and other company officers. So the new companies incorporated under the new company's ordinance must have Articles of Association, which will reflect the following matters. So first of all, the Articles of a limited company must state the liability of its members. It must state that the liability of its members is unlimited. I'm sorry, if we're talking about the limited companies, then the liability is limited. If we're talking about the unlimited company, that it must state that the liability of its members is unlimited. So the Articles of a company limited by shares must state that the liability of its members is limited to any amount unpaid on shares held by the members. Furthermore, the Articles of a company limited by guarantee must state that each person who is a member of the company undertakes that if the company is wound up, while the person is a member, or within 1 year after ceasing to be a member, that the person will contribute an amount required not exceeding a specified amount to the company's assets. In addition, the Articles of a company with a share capital must state the capital and its the company's initial shareholdings. The Articles of Association to be incorporated with the license granted under Section 103, where the company which with such license must state the company's objects whilst the license remains in force. So for other companies, it's not mandatory. In addition, the Articles of a company with a share capital may set the maximum number of shares that the company may issue. So kindly note that this provision is not mandatory. So it's talking about the first shareholders and first directors. The first appointment of directors is carried out at the meeting of shareholders, and the first shareholders is the founding persons who sign the company's Articles of Association. Their names are stated in the document and cannot be changed. First directors, as I have already said, they are appointed at the first meeting of shareholders. So if we were talking about the private company, where liability is limited by shares, there should be at least one director. If we're talking about the public company, there should be at least 2 directors, and the company has the right to appoint corporate directors as well. So the director can be not necessarily local. However, one director, if we're talking about the public company, must be a physical person. So the latest requirement, this is the latest requirement in the company ordinance. Subsequent appointment and dismissal of the directors may be performed in the same way, where at the meeting of directors, with the subsequent approval of the appointment, dismissal, uh, over the appointment or dismissal by the shareholders at the next annual meeting. So, talking about the directors, they are responsible for the timely submission of reports. Okay, I see your question. Okay, I will send to you the answer via mail, or maybe if we have time, I will answer you the question after the webinar. So, talking about the directors, they're responsible for the timely submission of reports to the government authorities and the payment of all taxes due. So, the director is not an employee. And actually, he is not paid unless he has signed an employment contract. So the director may receive an annual bonus, which is decided and approved at the annual meeting of shareholders. So it's quite difficult to find a nominee. If we were talking about the nominee service, it's quite difficult to find a nominee director in Hong Kong because the liabilities of directors under the new Hong Kong legislation is quite high. So, but it is possible. So the company secretary, if we're talking about the Hong Kong company, of course, must be a resident of Hong Kong. It can be both physical or legal person. All reports and changes must be submitted to the registry and signed by either the directors or secretary of the Hong Kong company. So the company secretary has the right to apply to any governmental authorities on behalf of the company and to obtain any information that is needed. So the secretary is also responsible for the timely submission of the annual return, for the registration of the changes in the registry. So it may be any changes regarding the directorship, the shareholding structure, the company address, or maybe issue of shares. The company maintains and stores the registers such as register of directors, register of shareholders, register of secretaries and auditors, directors shareholding, for example, interest of directors in contract. So any information should be maintained and stored by the secretary. In case the client decided to use the nominee service, he must know the following. So first of all, nominee shareholder holds shares on behalf of the owner. I'm sorry. In this regard, the declaration of trust should be signed by both parties, so both by the beneficial owner and the nominee shareholder who holds shares on behalf of the owner. And the instrument of transfer of shares with an open date. These documents should also be signed because based on these documents, any independent service provider can make changes to the registry as per the instruction of the beneficial owner. Nominee shareholders can be both individuals and legal entities. So actually, it should be stated that it is impossible to states protection of the beneficial owner against all actions of the nominee shareholders in the Articles of Association. So the protection of interests of the beneficial owner can be made through the Court of Hong Kong or other jurisdiction as stated in the Declaration of Trust, where as we can call it in the other way, the trust deed. So it's quite possible to do like this. So talking about the nominee director, we must emphasize that there is no legal term for this, like nominee director. Nevertheless, this service is still used. So as the risk exists for the client and beneficial owner, there should be the service provider or your lawyer should make everything to restrict the rights of in the documents. So to decrease such risks from the side of the nominee director, it's better to send the indemnity letter. And I'm sorry. I'm so sorry. I'm kind of lost. So we're talking about the restriction of the rights. You should remember that if the risk of disclosure of confidential information decrease, then there is a risk of unlawful actions from the nominee director. So to decrease risks from the side of a nominee director, there should be in the Articles of Association and some other documents, we should write as much as possible to restrict his rights. So first of all, the director has no direct financial interest in the company, and he should act only according to the instructions received from the beneficial owner. The beneficial owner exempts the director from the liability of a company management and from the responsibility for the decisions made, even they entail bankruptcy of the company. Because using the nominee service, using the nominee director service is possess high risk both for the beneficial owner and the director itself, because no one wants to bear responsibilities for the actions he hasn't committed, So it's vital to understand that all the documents signed by both the beneficial owner and nominee directors only partially protects both of them, as I have already told you that there is no legal term of the nominee director. So partially it's opposed to the law. So other protection methods against actions of the nominee director include entering the necessary changes in the Articles of Association. So the restriction of directorship powers, I have already told you. It will be effective in the event if there is a real shareholder in the company, but not nominee, or maybe when the shareholder is a different person. And it's also possible to appoint the second and third directors who, by majority vote, will prevent carrying out any undesirable actions by nominee director. So we should sign the following documents. First, the nominee service agreement, exemption of a nominee director from any liability, so-called indemnity letter, which so this indemnity letter will state that the director does not have a direct financial interest in the company, that he acts only on instructions received from the beneficial owner, that the beneficiary exempts the director from the responsibility for the management of the company. So any use of nominee service, and the last document that is to be signed is the letter of voluntary resignation from the director with an open date. So any use of nominee services shall be based on the selection of a reliable service provider with a solid reputation, who won't carry out questionable actions in relation to the company or the client, or will undermine trust to this provider in the future. So talking about the reporting or the papers that should be submitted by the Hong Kong companies, we should tell about the following. First of all, it's an annual return and tax return. In addition, the company shall pay for the renewal of the business license, which the cost of this depends on the submission of the annual. So if the complete payment of the license has to be made to the Hong Kong Inland Revenue Department, its cost depends on the submission of the annual return and on the service provider's fee. So the assignment of the secretary, director, registered office, nominee service. So the secretary must maintain all the registers and company protocols as it is required by law, and all documentation must be kept in the secretary's office during the lifetime of the company. So unlike the accounting and financial reporting documents, secretary documents shall be kept until the liquidation of the company. So the resolution are kept not less than 10 years, and the registers do not have a period of limitation. So, in addition, it should be stated that the note to the financial statements should also be stored during the 10 years, 10 years. In addition, the company can be reestablished. Sorry. Sorry. Talking about the accounting maintenance, we should state that it is obligatory in Hong Kong and it's required by law. So, however, changes to the ordinance that have been adopted recently list the companies. These changes list the companies which can prepare the reporting under a simplified procedure, and also for such audit requirements have been considerably reduced. So the companies by this criteria come under this which come under these regulations are as follows. So first of all, the companies which assets cost of the company is no more than 100 million Hong Kong dollars. The cost of sales, the companies which cost of sales isn't higher than 100 million Hong Kong dollars, and the company with no more than 100 employees in the company. So turning to the audit, it is obligatory for all types of companies, but not to the dormant ones. But the requirements of dormant companies has decreased. So the company is considered dormant only upon submission of relevant applications to the registrar. So you can't state that your company is dormant afterwards. You should state it prior to the year when you have to submit these to submit all the documents and complete the audit. So the preparation and submission of annual return is also required, but please do not confuse it with the tax return. So for the private companies, the annual return should be submitted each year within 42 days after the anniversary date of the company. So the financial statements do not have to be submitted at the same time. So for some other companies, on a certain date, this annual return should be submitted on the certain date after the completion of the annual audit and shareholder meetings. So the annual return must include the financial statements as well. Talking about the preparation and submission of the tax returns for the private companies, we can say that the tax authority normally sends out the tax return form around the 1st of April, and the deadline for the submission of tax returns together with the audit financial statements usually is stated in the form which is sent by the tax authority. There is a system of penalty for failure to meet the requirements on submission of the reporting. So if the report has not been submitted on time, there should be some unpleasant consequences, such as the cost of the renewal of the annual license can be increased, and the penalties for untimely submitted tax account can occur as a result of the legal proceedings. And of course, there can also be the penalties for untimely submitted annual accounts. So, talking about the company deregistration, it is possible only for the financially solvent companies that meet some conditions. Some of them you can see on your screen. So, first of all, the shareholders should give their consent to the company deregistration at the meeting. Then the government debts and settlements, like all financial reports to be submitted, and some liabilities towards external creditors, officers of the company, its employees, shareholders. All these payments should be repaid, should be paid out. So in addition, there should be no activities within 3 months prior to the filling of the application. The company has not be should not be involved in any lawsuits. The bank accounts of the company should be closed, and all assets shall be liquidated, then either sold out or returned to the shareholders. So it must be remembered that the deregistration from the registry depends entirely on the decision of the registering body. It can deny to perform deregistration and advise to conduct the winding up process. The whole process can take from 4 to 5 months. Directors of the company which have been removed from the registry shall store all the documentation for 6 years. But if the client wants, the company can be re-established according to the statement of directors or shareholders, and also by by court decision, for example, within 20 years from the moment of striking off from the list. So there can be both voluntary strike winding up and forced strike winding up. As you may easily guess, voluntary winding up will be carried out as per the decision of the shareholders, while forced ones will be made according to the decision of the creditors. So both assume appointment of the liquidator and is more expensive because of the remuneration to the liquidator, and is much more complicated procedure than just a simple strike off. So settlement with all creditors of the company, including external creditors on different levels, employees of the company, and also shareholders. So talking about the abandoned companies, service providers designed their internal procedures and rules on the risk taken of responsibilities for the cash companies of the beneficial owners. So company deregistration, but not abandoning of the company is recommended, because it may impose some more responsibilities, some more negative consequences, as well as penalties for the company. So we will recommend the registration, and the registrar might as well proceed with a forced strike off. Due to the ever-increasing importance of CFC regulations for business-related purposes in Cyprus, we have identified how we can help. We have expanded our services portfolio into property as well. So we have a number of unique properties on the market in Cyprus for investment opportunities. So if you wish, you may find out more about any of the properties on the screen. You can do so by entering your emails address in the chat box on the screen, and one of our property agents revert to you shortly. Alternatively, you may visit our website www.eltomaproperty.com. So you may see the services our company provides on your screen. So it's registration and maintenance of the companies. It's the creation and restructuring of the international holding structures, immigration services, accounting audit and preparation of the financial reporting, international tax planning, opening corporate bank accounts, some legal services, assistance in receiving licenses and registration of the trademarks, and as you might notice, holding seminars and webinars as well. So our contact information is reflected on your screens. Please do not hesitate to contact us if you have any questions or you need any services to be provided to you. So thank you for your time. I see your questions in the chat box, so I will send all the relevant information to your emails today. Hope the webinar was useful for you, so thank you for your time. Hope we will see each other one more time. So thank you. Bye.